Hello, everyone, and welcome to another episode of She Talks Business. I hope you're getting lots of value out of our advisor series. I know I have received some messages and feedback from people that they really value and appreciate the diversity of experts that we have had on the show. And today's expert advisor is no different. And I'm really excited to have a conversation with Matthew Asbell about all things IP related. So if you are listening and you are someone who has a book, you have a blog, you have a podcast, I want you to pay close attention because some of those assets that you're creating are worth money and you need to protect them the right way. So Matthew, welcome to the show.
Thanks so much, Lisa. Really appreciate it. Thanks for having me.
It's good to have you here, and I'm anxious to have this conversation with you because I think it's such an interesting topic, especially with everything that's going on in the world right now with AI. There's a lot of people that are paying closer attention to how they protect their information, I think more so than ever before. So that's definitely one of the things I want to chat with you about. But can we just start? I know that a lot of people, when I use the word IP, they stop me like, what do you mean? What is IP? Like, can you maybe just start by educating us a little bit on what is IP? What does it look like? What does it have to be considered IP?
Sure. Well, that's actually a question I have to unpack into sort of multiple parts. So I'll try to do a little bit at a time. Um, but I think the place to start is that we need to have common language in order to understand what each other means. And IP, or intellectual property, there's another version of that called industrial property. These are terms that people don't all mean the same thing when they say them.
Mm-hmm.
Uh, Generally speaking, intellectual property are the legal protections that come with creation. And they can be creations of artistic things and expressive
Mm-hmm.
types of things. This podcast, they could be the protection of new processes, inventions, medicines, things like that. Um, or they could be branding and reputation associated, right? Logos and names and things of that nature.
Yeah, like the Nike swoosh.
Like the Nike swoosh, yeah. So, so when you ask the kind of question, what is IP, right? I mean, pretty much anything created could be IP. Um, it's really what form of intellectual property might be appropriate, and sometimes there are multiple forms
Mm-hmm.
um, to protect what someone's doing and why they need to even bother protecting it.
So, for the purpose of our listeners, I know a lot of people listening probably have blogs, they probably have podcasts, they probably have, maybe a YouTube series. They may have books, they may have process visuals that they've created to illustrate the way that they work. Are all of those things what you would consider to be IP?
All of those things are protectable as IP.
Okay.
The things themselves are not IP. It's the rights that come with them. Um,
Okay. So that's a really important distinction. So your IP is only your IP when you protect it. Is that what you're saying?
well, yes and no, because there are some forms of IP that are automatic in terms of creating protections that you can utilize.
Mm-hmm.
And the systems that the government puts in place, or governments around the world put in place to quote unquote protect it, really to register it. Um, those systems usually are about providing advantages, um, over just the bare bones. I got the rights because I created something.
Mm-hmm.
So, you're recording this podcast. You own copyright in this podcast. You don't need to go and say, I claim it. It's mine. You don't need to put a copyright notice on it. You don't need to put it on a DVD-ROM and mail it to yourself. Um, you've created it. It's been recorded. It's the copyright exists already in what
Mm-hmm.
you've. But if there was a concern that people were taking pieces of your podcast and reusing them in their movies or their own podcasts, or doing anything with what you've created
Mm-hmm.
and worried about that, or there was a likelihood that that was going to happen, then taking the steps to go and what you said, protect, but what I would say is register your copyright would make sense rather than waiting until you actually encounter that problem. And then you have to
Right.
do it in a mad rush and pay extra to get it done fast. And you won't have as good protections dating back to earlier on when it started.
Okay. So let's talk a little bit about the difference between copywriting something and trademarking something. And when should you copyright, and is just using the C with a circle enough, or do you have to do something official? And when should you trademark?
Sure. So first off, it's common for people to use these terms as verbs, but they're not verbs. So you are registering a copyright, you're registering a trademark, but when you create the work, when you record the work, whether it's on a video, it's written down on paper, or it's typed into a computer and saved as file, whatever it is, that type of expressive work, artistic, creation, or even software code,
Mm-hmm.
that is already copyrighted just by the fact that you have written it and recorded it.
Okay.
So you don't need to take the added step of registering it, but you can, and there could be good reason to do so. Um, so can you put a copyright notice on this podcast when we're done? Yeah, you can. You don't need to go and register it to put a copyright notice on it. The
Right.
copyright notice is just telling the world that I claim this is my copyright and this is
Okay.
who the owner is and this is when it came out. Um, so, and it's not even necessary to do that. The law changed back in like 1976 that basically eliminated the need for um, this idea of giving notice of the copyright. But it's still a good idea because if you're going to go to court, you can say this person knew that I owned the copyright and you can point to the evidence.
Right. Especially in a digital world where people like it's terrible online. People steal each other's IP all the time and then rebrand it or remarket it as their own. I've seen people, rip off sales pages that I've had for events, and they basically just tweak the copy a little bit, change the name a little bit, but they followed the exact format and formula. Like they're really using my IP. They're just massaging it a little bit so they can say it's not exactly the same.
Yeah, that's pretty common, and there's some I don't know, dialogue going around in the small business community that if you do this certain percentage of change, that's enough. I don't know,
Yeah.
15% means I'm allowed to do it. That's
That's
not
like
true.
saying if you steal a Hershey Kiss instead of a chocolate bar, it's not grand. It's not really theft. Like,
Well, it's weird that even there's this complete misinterpretation of what the law is, and and people have somehow kind of quantified that as to this is how much I have to change in order to be safe. But
mhm,
you're right, it is rampant, and that's really because the internet and computers have made it accessible to people. So
mhm,
because the internet's out there and I can get access to this stuff, that doesn't mean that I'm allowed to use it.
right.
And using it can get me in trouble. Now you asked
Yeah.
another question, so I just want to make sure I answer that other part of the question, which was about
Yes.
trademarking or what I would
Yes.
registering trademarks. So that is different than I've created a work, I've created art, I've written something, I've created top software code. That is about branding and reputation. And what
Mhm,
we're talking about there is, you have a podcast that's called She Talks Business. So the name She Talks Business in association with the service of providing a recorded podcast, entertainment service or informational service, something of that nature, right? That is a trademark. And just like with copyright, the fact that you already do it means you have some trademark rights. So good news, you have some rights. And if you needed to enforce because someone else decided they wanted to be She Talks Business or something very, very similar for a podcast, let's say, you would have some recourse against them.
mhm,
But the recourse you would have would depend on the facts more so, um, because of there would be more limited circumstances where you would have that. If you went and took the added step of registering the trademark, applying to register the trademark, once you got that registration, you would be equipped with a broader scope of rights. Let's say your podcast only reached a certain part of the country. I mean, I know that's not true, but let's pretend that was the case.
Right.
Or let's say you needed to protect, but what the other person was doing was not, maybe it was in the same geographic territory, but it was not the exact same thing. It wasn't a podcast. Maybe it's a blog, and somebody offers a She Talks Business blog that you don't offer. And you wanted to be able to stop them. Having the registration is going to give you those broader rights to be able to enforce that. So you can go and register the trademark, and it's usually a good idea, but there's a balance between registering everything that could be a trademark every which way you can on day one, and not doing it at all, right?
Right. Typically, you would have a little bit of use, like a little bit of use of the words or whatever it is before you would move to the actual registration phase, would you not? Or is it better to register first and then use later?
So you
I know
can't,
that.
sorry.
I was just going to say, I know I have a client that has trademarks, and whenever they apply for a new trademark, their attorney always asks us to provide examples of where it is being used on their website.
Yeah. So let me differentiate a few things. First off, you can file an application to register a trademark without having use. So that we have what is called an intent to use trademark application. And that can be essentially backdated to when you filed it, and you later have to prove use in order to get the registration in the process.
Gotcha. Okay.
So intent to use is a really good tool when you're preparing to launch something, and you want to secure it in advance. You don't want to wait till you've done it. The risk of just doing it without having registered the trademark, and without having applied to register the trademark, and without having done a search, is that you may unwittingly or even knowingly, but I would assume unwittingly, be using a trademark that belongs to someone else. In other words, you may be infringing someone else. You didn't mean to, but since you didn't bother to check, you didn't find out that someone else owned trademark rights, registered trademark rights, potentially, that could block you, and could end you up in court, right? Defending a lawsuit or having to rebrand at a very high expense.
And is it easy for an everyday person to do a trademark search, or do you need to hire an attorney or a firm to help you with a trademark search?
So doing the search, there's some limited searching that you can do on your own. That doesn't cost anything. You can go to uspto.gov, which is the Patent and Trademark Office website of the United States. We're talking about the United States only for the time being. And there's an option there to do a trademark search, and you can type in your name, that you're looking for, and see what comes up. Now, the problem with doing it yourself is, if you're not somebody who does this every day, you don't necessarily know what would be problematic for you, because it may be some slight misspelling, or different spelling, or spacing of the wording in there that would still be similar and still be problematic, but you just typed in the word and looked to see if you had the exact thing. So the person who's trained and knows about trademark law knows how to evaluate what you can find. And it's not even, and it's not only that you find something or you don't find something. If we do find something, there's a lot of junk out there. There's a lot of stuff that, yes, somebody got a registration, but they're not entitled to keep it. And there's stuff we can do about that if it's the thing that's blocking you. So we're sort of looking on a defensive side of, let's make sure you don't get yourself in trouble. Yeah, you can look yourself, but don't rely on that. You probably want to have an attorney who knows what they're doing do that. And then, apart from making sure you're not infringing someone's rights, let's also see if we can register these rights for you. What are the obstacles? And if there is some person with prior rights registered or uses, how do we mitigate those risks? How do we plan around it? And we strategize. But look, if you don't have a lot of money, I know plenty of people who have either gone ahead without a search, or have done their own application, or done their own search. and done their own application and gotten their registration, and it is possible to do it.
Yeah. I, I think, as a starting point, going to that website and doing a search, and maybe, even for me, the first search I usually do is Google, because I want to see, is somebody else using the name somewhere, and is there a trademark associated with it? And if I can't find anybody using the name anywhere, I automatically feel, at least myself, like my risk is low because it's not being used by someone else. So that's kind of where I start. My next question for you, though, is like, what should we trademark? Because, when you're creating stuff all the time, how do you weight and determine what things should be trademarked and what things should not be trademarked?
I think the easy answer to that question is what's important, but maybe that's not really a fair answer, because how do you know what's important enough to trademark? But I would say, something that you're planning to use in the long term, something that is years or decades, in terms of a reputational, brand that you want to use, is worth protecting as a trademark. Whereas something you're like a campaign, a tagline or a slogan for a campaign that's going to be for 6 months, why bother? It's going to take you, you're going to stop using it before you even get the registration. So that's one guidepost to use. The other thing that I encounter a lot, particularly with like my small business clients, is they have a name and then they have a lockup or a logo, like a graphic or a font that they use, and sometimes with a graphic in different positions in relation to the name, and all of those things could be separately trademarked. But then there's a multiple, of costs. So if they have the money, then I would tell them, hey, let's do all these things. But when they don't, we need to prioritize and basically have a longer term plan. Let's do this first, and in 6 months we'll do that, and then in a year we'll do this other thing. And the same goes with, I'm doing it for this product, but I'm going to be using it for these other products later. And having a plan in place, hopefully in consultation with someone who knows how to plan it out with you, helps you to make that decision. Today is the one I need to do this, and I can put these other things off, but let's have a time where we regroup and not just leave it to remembering when we should. So I would say, for these businesses that have a name and a logo and let's say a name and a graphic and then a lockup with the name and the graphic as an example, the name, the protection of the name is the broadest scope of rights they could get. So that may be more important. In many instances, that will be more important than protection of the logo version with the words. The other aspect of a trademark registration is what you register is what you've protected in terms of the uses you've protected. So if you have a graphic and you use the graphic sometimes above the word and sometimes to the left of the word, in theory, I could tell you, well, let's go register the word, let's go register the graphic by itself, let's go register the word with the graphic to the left, the word with the graphic above, and the costs are crazy.
Overkill.
Yeah. But if let's say we protect the word first, we might need or want to use the graphic and protect the graphic alone. So that way, if we protected the word and we protected the graphic independently, we can move them around anyway, which way we want to. We don't have to worry about the lockup of the graphic is always to the left or above. Right. So, and sometimes there's a good reason to pursue the logo version over the word mark because you're worried about a risk. I'm worried that my mark may be refused because the trademark office will think it's descriptive of what I do. So maybe a way to better ensure that I can get the registration might be the lockup version instead of the word by itself. So various things come into play, but you kind of weigh all these different things.
Yeah. It's a lot to think about. And I think I like your point that, you should be thinking long-term about whether you're going to be using whatever it is on a long-term basis, because, it can cost thousands of dollars depending on what you're trademarking. And if I understand correctly, if you also have to trademark by country. So if I trademark something here in the United States, that doesn't mean it's trademarked in Canada. I have to apply for trademarks in each country. Is that correct?
Yeah, I mean, there are different mechanisms available to protecting your trademarks in different countries. Um, but if your market is in a foreign country, if you're producing in that foreign country, there's good reason to go and register the trademark in that
Mm-hmm.
country. And yes, that will add a significant amount of costs.
Yeah.
So there's even a plan that you would put together in terms of these are my initial key markets. These are the markets I'm going to next. This is where I'm manufacturing. This is where
Mm-hmm.
I'm worried about counterfeiting.
Yeah.
And you don't, and the other thing that's interesting about the foreign trademark aspect is you mentioned this idea of use, or we talked about intent to use or use in the United States. That's a US specific requirement. Most countries around the world don't require proof of use or even
Mm-hmm.
use to get a registration. So if I want to preemptively protect myself, I go and I take my name and I go and I register it in Canada. I don't
Mm-hmm.
have to have use in Canada to get the registration.
Interesting. Interesting. I just had another question I was going to ask you, and now it's left my mind on the topic of trademarks. It'll come back to me. It
Well,
always
you were
does.
gonna. There was something you were asking about the logos. I think I can maybe hammer home a point anyway. What about the difference between the color version of my logo and the black and white version of my logo? Why, if I use it in green, why am I not registering it in green? Should I? And that goes to that discussion we just had about short term, long term. Yes,
Mm,
green is my color today. Will green always be my color? Am I Tiffany blue? Like, how much do I care about the color? Or is it more that
right,
I breadth and I want to be able to use it? I'm Apple and I used to be a rainbow and now I'm white. You know,
right,
if I have a registration that's black and white, I don't have to worry about refiling when I change.
right,
Um, but I'm also not claiming ownership of those colors.
right, right. The question I was going to ask you uh, is about defending your trademark. So when you get the trademark, it's not enough to just have a trademark. You have to pay attention to who's using your trademark, because if you don't do anything when somebody's using your trademark, then your trademark is essentially useless. Like I've had this conversation with clients of mine where, oh, I think I'm going to trademark this thing. And I'm like, okay, and are you going to monitor use? And are you going to actually have your lawyer or you send people a letter every single time they are using your trademark? And they're like, well, no, I don't want to do that. I'm like, okay, well, then you probably don't need a trademark. So can you talk to us a little bit about what type of due diligence is required when you own a trademark to ensure that you are upholding the trademark?
Yeah, sure. So that is true. That if you don't enforce your trademark, if you later try to enforce it, right, someone's going to have a defense against you to say, well, you didn't enforce it, so you shouldn't be able to enforce it against me.
And how long is that period of time typically?
It's not really a specified period of time. It's
Okay.
up to the courts. Um, you know, the courts don't expect you to have to go after everybody, every which way, every little thing. You can make those decisions, um, but uh, you should have a plan in place. And I
Mm-hmm.
think all the real problem in the business community or the disconnect with trademark law and lawyers is that people think of registering a trademark or trademarking as like going to the store and buying a product. They feel like they're getting an asset. They need this asset, and then when they have that asset, they're going to be okay. But it's not, right? It's a process they go through from clearance to searching, clearance to filing to getting the registration, and monitoring and enforcing and having a plan over time.
Mm-hmm.
People don't like to hear that because they're seeing the dollar bills kind of go
Right.
away. But
And so many people are non-confrontational. So they don't want to actually tap you on the shoulder and say, "Hey, you're using my trademark." So they avoid it.
yeah, yeah, that's true too. But I mean, they should at least be evaluating and deciding, proactively or have a policy as to when
Mm-hmm.
do we take action. And, if they have proper advisors, they can have a partner in that process. Um,
Mm-hmm.
which doesn't necessarily mean that they have to be spending an arm and a leg, to do all these things. Really you need to be working with someone you trust that will be looking after your needs and understand the budgetary constraints you have, but we'll
Hmm.
still ping you when, this looks problematic and we should do something about it, and try to encourage you when you really should take action.
Hmm.
And I think to your point, if you're not willing to do anything and you just look at this like the asset of the thing you need because it's going to get you on Amazon brand registry, or uh, you know, because someone told you you need to register the trademark, but you're not actually going to be watching the marketplace or reacting to others who try to, ride your coattails. There's not much point in
Hmm.
seeking the registration or claiming the rights.
Yeah. I have been reactive when it comes to registering my own trademarks. I have two. And in both cases, one time someone asked me, "Oh, that's a really good name. Is that trademarked?" And so right away I was like, it's in the process, because I was like, somebody wants to use this. They're asking me if it's trademarked. And then the other time is there was a term that I've used for years, and it's even in both of my books. And all of a sudden I saw someone else using that term. And I was like, okay, that's my term. Like, I own that term. I'm going to do something about it. And so I have a second one for that. So, sometimes if you just pay attention, you start to see the things that you own that are the ideas or concepts that are valuable to other people. And you can take a little corner of the world and put a stamp on it and say, I own that expression, so to speak. So
Uh,
let's shift gears
cool.
and let's talk a little bit about AI, because AI is, and you may not even know the answers to this yet. I don't know if there are laws around this yet, but there's a lot of people out there having conversations around how does AI affect their intellectual property? Because when you ask ChatGPT a question and it gives you an answer, it's not necessarily always telling you if that answer is trademarked or copyright. And there are also these great little, yeah, tools now like Chat Thing that you can add to your website, and you can train these AI tools on your body of work so that they can answer questions. But when you put your information into the AI universe, does that mean you're foregoing your protections? Like, how do people navigate this new world of AI?
It definitely is a new world, and there's not a lot yet out there. There are some cases that are working their way through the system, um, but there is guidance, and efforts at guidance coming from the government. The U.S. Copyright Office has been, you know, talking about this for many months, maybe even, well, I mean, technically years, but recently a lot more. The FTC, the Federal Trade Commission, is also, you know, taking interest in this. There's a lot going on. The AI is the hottest topic,
Mm-hmm.
globally on anything, I think. Um, so you have to start from a couple premises, and we always have to look at this from a defensive and an offensive perspective, right? We are trying to make sure we don't get in trouble for the things we do, and we're trying to also make sure that the things we do can be ours if we want to own them. Uh,
Right.
and and so the analysis kind of starts there, and and maybe at a first blush, um, the concept of using generative AI to create something. Um, I'm going to write a blog post. I go to Chat GPT and I say, hey, write me a blog post about artificial intelligence and intellectual property law. Um, I love what it wrote. I adopted wholesale, probably not. Um, and then I post it, let's say on a social media site, or on my law firm website, something like that. And then I see someone else has got, the same verbiage, or similar verbiage, and and that bothers me. So do I have rights? Well, the Copyright Office and the copyright law say that if it is not created by a human, it is not protectable as a copyright.
Mm.
Now, was it not created by a human? That's a different story, because, of course, the way AI works, these large language models are training based on what's out there.
Right.
So, what it does produce can be wholesale new. It can also be based off of someone else's work and
Right.
therefore infringing, right? So there's a case right now in the courts about images because Getty Images, the stock photo site, um, is suing an AI company, Stable Diffusion, that you can type in, I want an image of a cat wearing a scarf, and it will go and take having learned all these images about cats and scarves and whatever, and it'll give you a cat with the scarf superimposed on it, and you go use that. But in the course of doing that, it trained on, or it seems like it trained on Getty
On
Images
Getty's images.
photos. So they're saying that you copied my images to train on them, and that was infringement. So
Right.
there's a lot to it. So
Well, the image thing
it's not,
is so imagery is so interesting, even in the work that we do, because we do website design and logo design and branding and stuff like that for our clients. And one of the things that I'm always having to explain to people is that you own the finished product. You don't own the layers that went into that product. And people don't always understand that. We'll create an asset for them and they want the working file. And I'll say, well, you have to pay extra for the working file. And they don't understand why. And so then I say, okay, well, when you go to Gordon Ramsay's restaurant and you order a dish, the dish comes to the table prepared. That does not give you the right to go into the kitchen and find out what all the ingredients were and exactly how he cooked it. And so I think people sometimes don't realize that those layered files, when it comes to imagery, that artistry is actually protected. And if you want access to that information, there's an additional fee for it.
yeah. So I mean, I take a little bit of issue with your analogy because the culture of chefs is one of sharing. So generally, if you ask the chef the recipe, they'll tell you. They don't
Right,
care
but
that you don't know. That. But to your point, right? I mean,
yeah, like Colonel Sanders isn't going to give you the KFC, chicken breading recipe, right? Like, there's just, I mean, and if he is, you're going to pay a lot of money for it, right? Like,
yeah,
I agree. I agree. Chefs may be willing to do that, but the additional element of taking you into the kitchen and showing you how to do that, you're not going to get that level of access without paying a superior fee for it. And when you give somebody a layered file that a designer has created, you're essentially giving them all the different components and how they were put together. So
yeah, I can see that point. Just sort of the sidebar of the chef sort of threw me off a little bit there, since that just culturally that's different. But look, there are people who would bypass using a graphic designer and marketing company to generate a logo. I can go online to logomaker.com to ask for a logo to be created.
yeah.
What nobody realizes, or at least so they never read the small print, and I did this literally like a day or two ago. If you read the terms of service on logomaker.com, they actually say you can't use this as your trademark. You can't register the trademark. It's not yours. It's permission. You have permission to use it, but it's not yours and ownership.
And
And so
therefore somebody else could have permission to use it too. I'm assuming.
somebody else could have permission to use it. You can't stop anybody from using it. You're just in
Yeah.
a terrible situation. But yet that's what people do because the internet has made the access available to people. They can, at a low cost or a free cost, go and get something done. Like, okay, well, I'm going to go get a logo. They don't know any better. They aren't going to think about, hey, I want to have this thing and I want to own the copyrights in it. And I also want to register it as my trademark.
Right.
Um, so these are, there's a lot of pitfalls because of this idea of these things, this information that's readily accessible to us. And because people don't have time or really pay attention much to the details of what are they getting when they use a particular
Oh,
type of.
I've lost your audio there.
Oh, I'm still here. Hello. Did I not come back? Hello?
No, you're not
I'm
there.
still
I
going.
can't hear you.
Hold on. Trying again.
Oh,
Yes, I'm back.
such great conversation.
There's no reason I should have lost my.
There you are.
Okay, I'm
You're
back.
back now.
Okay.
Yeah,
I don't know what happened there, but all right, we're here.
that's okay. It's the AI gods saying you're giving away too much information now. So let's talk about the opposite. How risky is it for people to put their own IP into these AI tools? Because one of the things that people do is they will take a tool like ChatGPT, and ChatGPT is my new social media manager. And the best way for ChatGPT to write content for me is if I get ChatGPT to ask me a bunch of questions about myself so that it can learn my language. How risky is it for people to be doing things like that, and or taking some of these chat bots and uploading manuscripts so that, the AI tool has access to the book that you wrote to answer questions when people are on your website?
So I guess I have two initial responses to that question. First of all, um, before you go and post it into Chat GPT or some other AI platform, um, wouldn't be a bad idea to like have written it out and saved it as a file already on your computer, right? Because
Mm-hmm.
the copyright then existed before it was given to
That's really good advice.
to the chatbot, right? Um, and so that'd probably be, a good way to at least establish a record of that ownership. Um, the second thing I would look at is what are the terms of service of the particular platform you're using? Because, and this applies not just to the AI and chatbots, but also to social media platforms.
Mm-hmm.
Um, when I upload my content, am I giving a perpetual license without any fee to the proprietor of that platform to then do anything with it anywhere over the world around the world? That can very well be the case, um, and it very often is. So this idea of, well, you're putting out your stuff there for free in a place where it maybe other people won't necessarily be able to take it and do something with it from there, but the owners of the platform may have been granted a license and may have some valuable ability to use
Mm-hmm.
and to grant others to use, uh, to use those rights. So you do need to be aware of those terms and conditions. Nobody wants to read them, but
I know.
I mean, that's why you have us. I mean, hopefully you have somebody who knows it enough and can answer the question on a particular platform.
Well, that's a great segue into the last question I have for you. And my last question is when to work with an advisor versus DIYing it. So, can you talk to us a little bit about the risks versus the rewards of going it alone and having an actual advisor who understands this stuff?
Yeah, sure. So it depends on what it is you need, but like going it alone in terms of registering a copyright in something you've created, I think it's not that big of a deal. It's not that hard to go do. You go to copyright.gov, there's a wizard you go through. There might be some questions you struggle with. Maybe you'll need somebody to give you some information. I don't think, somebody had a question about that and asked me. I don't think I'd charge them for that, right? I mean, just
Right.
not a big deal. It's a quick answer. Um, so that's fairly easy. I said that I do know people who've done trademark applications and registrations that way. I find that to be much riskier
Right.
because people don't really understand what risks they're taking and what might happen, and they sometimes pin themselves into a bad position and have that we necessarily can't necessarily clean up after the fact. And sometimes it just costs them more to clean it up after the
Right.
fact. So, I think it's a good idea to have counsel. I mean, of course I would think that because that's what I do, and I would want everybody to come and hire me, right? But but like I said, I do know people who have done it. And I think, look, if you really don't have any money, I mean, I guess you should question whether there's a value in getting the registration in the first place if you actually don't have a business plan and a budget set aside.
Mm-hmm.
Um, but if you're extremely limited and you want to take a first pass because and hope it works out, it's just a risk taking, it's a risk seeking activity.
Yeah.
Um, and there are programs available where you can get either free legal advice through like a law school or you could
I've
get,
lost you again. Your audio's
oh
gone.
no, that's terrible. Why is my auto disappearing? I'm here. I'm here. Can you hear me? Hello. Still no? Trying again. Hello. Can you hear me? Hello.
Right.
Like, so weird. All right, switching. Hold on. How about now? Does this one work?
Okay. Yeah, I can hear you now.
God.
So you
Uh,
were saying there are programs.
there are programs where you can get free legal advice through law schools, for example, law school clinics. There are free mentoring programs where even if it's not legal advice, you can get information. Um, and there are plenty of attorneys, including myself, who are happy to share information. And it doesn't have to be for a fee. You know, with the idea that, eventually maybe you'll come and hire me to do work for you because I helped you with X, Y, and Z and you appreciate it. So I would say at least have those conversations with a few people.
Mhm.
Also, DIY versus counsel. I mean, not all utilizing of a lawyer is the same. Some lawyers charge hourly rates, some charge flat rates, some charge contingencies, success fees, some have hybrid relationships, and some have all sorts of options available. So know what the options are,
Mhm.
relate to the person, know that you trust them, but
Mhm.
have those conversations. And then you know what, if ultimately you decide you want to do it yourself and you're comfortable taking a risk, okay, good luck.
Yeah, I think you have to look at the value of the piece of IP that you are considering copywriting or trademarking. I know I'm using a verb again, but registering a copyright or registering a trademark for. When I registered my very first trademark years ago, it was for a coaching program called Profit Pods. Well, that coaching program generated $250,000 a year in sales annually. So it was really important to me to protect my name. And I didn't want to mess around with it and do it myself because I didn't want to run the risk of it not being done properly and therefore not being defensible. And I wanted to be able to hold people accountable if they were using my naming structure. So I think, sometimes if you're listening to this, you have to weigh the pros and cons. If the thing that you want to trademark is something that generates revenue in your business, what is the potential loss of revenue if you were forced to change the name on it? And if it's something that is not a big deal to you, it's easy to change, then you might not want to invest money in it. But if it's something that's really important, it's central to your identity or the identity of your business, then I think, like anything, you need to hire an advisor who has more experience than you do on that particular topic to help you do it well.
Yeah, I agree. I would add that um, it's not just the cost of having to rebrand something. Maybe that's easier to do. If you're in a litigation where you're defending a litigation, you're going to be really spending a lot of money. Um,
Mhm.
so so it's not just the rebrand. You could have to pay damages. Um, Another thing, two other quick points, if I may. One is that getting that registration also gives you an asset that you can refer to in your accounting on your balance sheet for your expenses, and so there's value there just in actually having something you can list, as
Mhm.
opposed to saying, well, I kind of own this name-ish, because you haven't registered it, but you use it.
Right.
And we didn't talk much about patent, but patent is a kind of intellectual property on
Mhm.
an invention or process or machine, and that is even more complicated to
Mhm.
do and do right. So
Yes.
there are these services out there. They'll say, "Hey, we'll help you file a patent application really cheap,"
Yeah, it's
and
not worth it.
yeah, that's. I mean, I
Yeah.
think you really need an advisor for that.
I 100% agree. I have several clients that have very in-depth patents, and I don't think they would have been able to get the patent awards that they have without working with a professional. So thank you for bringing that up. That's a really, really good point. Um, Something we don't often think about, patenting some of the things, the processes that, or the inventory, whatever it is that we create, whether it's software or whether it is an application, whether it is an actual physical object. We need to be considering that as well. All
Yeah,
right. Well, Matthew, I think I could talk to you all day about this, especially the AI stuff, because I find it so fascinating, but I want to be respectful to our listeners and keep us on time, and I want to be respectful of your time. So thank you very much for everything you shared with us today. It has been exceedingly valuable. For those of you who are listening, you can find Matthew at offitkerman.com. That is the firm that he works for, but I will be sure to include his links to social, etc., the link to his podcast, Intangify, in the show notes, so that you can find your way to Matthew in whatever way works best for you. Thank you so much for listening to this episode of She Talks Business. And thank you, Matthew, for being a guest.
Thank you so much for having me, Lisa. Really appreciate it.